Court of Appeals in Dallas, Texas is now in session. Justice Shank presiding.
Good afternoon, everyone. Do we have everyone?
Yes, Your Honor.
Yes, Your Honor.
Let's have, if you don't mind, can we have appearances? I'm trying to switch to grid view just to make sure I do.
Yes, Your Honor.
We have Mr. Allen for the state, Mr. Lassiter for the appellee. Okay. Well, very good. Welcome, you both. Justice Partita Kipnis will not be joining us today for the oral argument, though she will be participating in the decision of the case. We have one case on our docket this afternoon. That is the State of Texas versus Holly Henderson. It's number 0519-01298-CR. Gentlemen, I assume you've done this before, but just as a reminder, I'll give you the rules of the road. We will hear first from counsel for the appellant. We'll have 20 minutes. There's no law that says you must take the full 20 minutes. But as you get closer, you will see if you have the window open, and I'll ask if you do. Do you see a window open with a clock with a timer on it?
I do, Your Honor.
Mr. Lassiter, do you have that as well in front of you?
I do.
Okay. The yellow light will come on and warn you, I believe, when 2 or 3 minutes are left, that if you go that far in your argument, that'll be your warning that you're running out of time. Unless the question is pending from the bench, at the time it turns red, we'll ask you to conclude your arguments and yield the virtual podium to your colleague opposite. With that, I think we know where we're going, so I will call the case. We'll hear first from the state. Mr. Allen.
Good afternoon, and may it please the court. My name is Jesse Allen, and I'm here today on behalf of the Dallas County District Attorney's Office, representing the state of Texas. The state respectfully asked this court to reverse the trial court's order suppressing the chemical analysis of appellee's blood in this driving while intoxicated case, because the trial court mistakenly concluded that the state had to complete post-seizure chemical analysis of that blood within 3 days from the issuance of the warrant, exclusive of the day of issuance. Now, the general rule for a search warrant is that it must be executed within 3 days after it's issued. But Chapter 18 of the Code of Criminal Procedure does not specifically describe what actions a peace officer must take for the expiration of that time. Now, after both parties submitted their briefs in this case, this court issued its July 9th opinion in State versus Jones. And after this case was set for submission, the court granted the state's motion to publish that opinion. Jones resolves the issue in this case. The appellant in Jones argued that because this court's decision in State v. Staten allegedly merged the requirements to justify blood analysis with the requirements for obtaining a blood warrant, that the time frame requirements for testing blood are controlled by the time frame requirements for blood draws. In other words, the same argument that was made here, that 1807A3 controls analysis, not just seizure. Now, this court rejected that argument and plainly held that Article 1807A3 provides the deadlines for seizing evidence, not analyzing it, and that the execution of the warrant is the blood draw, not the testing or analysis of that blood. In this case, the police executed the warrant timely by seizing the appellee's blood on the same day that the magistrate issued the warrant. Now, this court's holding in Jones makes sense because the provisions of Chapter 18 governing search warrants suggest that a search and seizure warrant issued under that chapter is executed at the latest when the target item in the warrant is seized. Article 1801 of the Code of Criminal Procedure defines a search warrant as a written order issued by a magistrate and directed to a peace officer, commanding him to search for any property or thing and to seize the same. Article 1806, which is the only expressly titled provision in Chapter 18 dealing with execution of a warrant, has various provisions of it that clearly indicate that when we're talking about executing warrants, we're talking about seizing property. It says that the officer, before taking property from a place, must prepare a written inventory of the property to be taken. He has to endorse his name on that inventory and present it to the owner or other person who is in possession of that property. And if no one is there who is in possession of the property, he leaves it there at the place from where the items were seized. So the warrant, at least according to 1806, is executed by searching for and seizing the property to be taken. And seizure in the context of property means restraint of that property, or it includes the collection of the property and taking possession of it according to Article 1809. Nothing in the description of how warrants are supposed to be executed in Chapter 18 aligns with the appellee's position at trial that testing for blood alcohol is part of the execution of a DWI blood draw warrant that commands the seizure of a blood specimen. Intangible results are not the item named in the warrant, the blood is. And test results are not taken from the place to be searched, the blood is. Now, in the court below, the appellee cited two provisions of 1807 that deal with varying amounts of time to execute search and seizure warrants under Chapter 18. The first was 1807A1, which deals with obtaining specimens for DNA analysis and comparison. That provision provides that the period allowed for execution of a warrant is 15 days if the warrant is issued solely to search for and seize specimens from a specific person for DNA analysis and comparison, including blood and saliva samples. Now, that's our position that provision is clear. It's not ambiguous. It's clearly talking about an execution time for obtaining the specimen. But if for whatever reason someone could say that language is ambiguous, and that the language talking about for DNA analysis and comparison somehow incorporated the testing phase of that evidence analysis into the execution, the statement of the bill sponsor, which we put in our brief, cleared that up. The bill author / sponsor was clearly concerned with individuals evading the police so that the police couldn't get a sample at all. And it amended the law to provide for execution of the warrant to obtain the specimen and not to test that specimen. The other provision that was cited in the court below deals with data and information on devices, various storage devices that contain electronic data or information. And that provision provides that if a warrant is issued to search for or seize data or information contained in or on one of various listed storage devices, the warrant is considered to have been executed at the time the device was seized before the expiration of the time allowed. That provision does not, and it's important, I think, to note, that provision does not extend the time to execute the warrant. It's very likely that, well, it is the case that those are going to fall under the general provision of 1807A, which is the 3-day provision. It doesn't extend that time. It simply defines when seizure occurs, and it occurs when the tangible item that houses that intangible data is seized.
Counsel, I appreciate these arguments very much. I'm trying to keep straight for myself. How many of them are open after our earlier published opinion? I mean, what authority, in your understanding, does this panel have to overrule an earlier panel decision on point?
I believe it has no authority to do that, Your Honor. For purposes of these arguments that I'm making right now, basically, if there was any questions the court had to clarify that as to what the court was saying in Jones, which I don't think there really is, I'm not aware of any precedent that would allow this court to just turn over that prior published opinion at this point.
I understand that. I wonder, have you communicated with Mr. Lassiter about the Jones opinion, or is he hearing about that today?
Yesterday, Your Honor, I submitted a letter to him and I submitted to the court for filing. I got an acceptance notice stating the additional authority for that we would be relying on for oral argument. I don't see that it appeared on the court's portal yet, but I got the acceptance back from the clerk yesterday.
Okay. I'm looking at Justice Osborne and wondering if it's okay with her if I ask Mr. Lassiter a question real quickly. Lisa, can we pause Mr. Allen's clock for a second? Mr. Lassiter, is it your understanding that any arguments you'd want to make on this point need to go up from here? Do you agree that there's nothing for us to consider in connection with the legal arguments that were made in the trial court in your case?
It's pretty close, Your Honor. I don't know that I have much of an argument after the Jones decision came out. There are one or two just slight differences, but I think the ruling in Jones is something that's probably going to have to go up.
All right, with that, I think, Mr. Allen, that might help you speed along your presentation here a bit. Let's get you back on the clock, then we'll let Mr. Lassiter make whatever arguments he wants to make about this opinion. Sorry about that interruption, but I think we can save some time here.
No problem at all, Your Honor, and I appreciate that. And given that, we would simply ask the court to reverse the order of the trial court granting this motion to suppress and remand it to the trial court for further proceedings.
Thank you. And with that, we'll now move over to counsel for appellee. Mr. Lasser, we welcome whatever you would like to tell us.
Thank you, Your Honors, and may it please the court, the one thing that I think is, and perhaps the only thing that is different in this case, as opposed to the case in Jones, was the case in Jones was first and foremost a Martinez argument. I assume I don't have to go into the details of Martinez. In this case, there is a difference, and the difference is in the warrant language. In point 19 of page 6 of the warrant in this case, it reads, further, the affiant requests the authority to forensically analyze the blood seized pursuant to this search warrant application. So the difference in this case is the only thing that the court was ruling on in the trial court was the 3 days for this forensic analyzation request met. Now, without going into Martinez, what Martinez does stand for is that the analyzation of the blood is a separate and distinct search. That's in the plain language. So I don't think we can argue that there is somehow two different searches that are occurring. The arguments in Jones.
If Martinez was decided before Jones, and I believe it was it not? Jones would be incorrectly decided then by your understanding of that argument, would it not? Because there would be a separate search.
Without going into a Martinez argument, based on whether or not it's a separate and distinct search, what I believe is Jones is not, as far as the Martinez case is saying, that Jones needs to go up and the Court of Criminal Appeals needs to reverse Jones on the basis of saying that it was not a separate and distinct search. What I believe Jones to state is that the search is covered by the warrant application. When you say, hey, I want to get a search warrant for their blood, it also encompasses hey, we also want to test this. I believe that was the distinguishing factor in Jones. And Jones is saying we're not differing from Martinez because in Martinez, it was a separate or distinct search for which you needed a warrant because it was for a medical purpose that they gathered the blood and then they did not get a warrant to then test the blood. So that's how Jones and Martinez are able to coincide in the same world together. But the reason that Martinez is applicable to a certain degree here is that Martinez is saying it's a separate and distinct search for which there needs to be a warrant. And what Jones is saying is that you don't need two warrants. You can do it in one warrant and simply asking the court without the specific language, we also want to forensically analyze. That's included within the assumption, the meaning of that initial warrant. Though here it is different because the state in this particular case actually put in language asking to forensically analyze the blood, which it had not done in the Jones case to the best of my understanding. So here we have a case where the court granted the motion solely on the basis of because the state put in the language of the warrant, we want to get a warrant here, not just to seize the blood from the subject, but also to test the blood. What the court in this case was saying is, yes, you seized the blood, but you did not test it, and your specific language in the warrant says affiant requests the authority to forensically analyze. So that—
Can you help me out? I'm just having a little difficult time understanding when, for Fourth Amendment purposes, the government would be interested in seizing blood, but not analyzing it.
So as far as, I don't know of an instance in which you would seize blood or any other substance and not intend to test it at a later date. But the Court of Criminal Appeals in Martinez, when they stated this is a separate and distinct search, all I have to go on is the court is saying that is a separate and distinct search under the Fourth Amendment for which a warrant is required.
Now in Martinez, was there a warrant?
In Martinez, there was not a warrant. Martinez was a medical blood draw in which the police seized the blood after the fact and then tested the blood. When the blood was initially drawn, it was drawn by medical staff. And then when it was tested, there was no warrant for the testing. And so the Court of Criminal Appeals said, you've got to get a warrant for that testing. But the important portion of that was saying, this is a Fourth Amendment test. The testing of it was a search, which we had never had prior to that date. It had always been considered part of, like the other justice mentioned, the same transaction. The seizing and the testing was all kind of one before that. It was not a separate and distinct search.
If the government has the authority under the initial warrant to make the seizure of the blood, what other than the statute we construed in Jones would constrain its ability to conduct the test or impose a deadline on it?
The only thing, and that's what I was pointing out, that is different in the Jones opinion, is that in Jones, to the best of my knowledge, because it came out yesterday, or I saw it yesterday, and I don't know the facts behind it, did not specifically request in the warrant the right to test the blood. And that's what
That's why I asked you the question I did. When, and you're giving the best answer a lawyer could possibly give to my question. When would the government be seeking to draw blood for any purpose other than to conduct the analysis that would naturally follow?
For the purposes of DWI, I don't think that there is a
I don't either.
logical answer that I can give you to say you're going to seize the blood as a police officer and not intend to test it.
Well, that's why I think you're doing a fine job trying to distinguish Jones, but I'm struggling with you, I think, to understand the significance of the distinction.
The only significance that I can...
Well, let's take it, let me take it this way. Here's a hypothetical. Your client, instead of being arrested and having the blood drawn, walks into a police precinct bleeding and says, give me a cup, and bleeds into the cup and says, here, I yield all interest in this for the rest of my life. What's the problem with the search at that point?
There is no problem because he's...
Okay, and if they analyze the blood, would Martinez say there was a problem?
Until the Court of Criminal Appeals comes back and says, once the blood has been seized, there is no privacy interest in that blood.
Right. And if the blood is seized, but pursuant to a valid warrant, where would we or by voluntary action, where would Martinez direct us to a different result than Jones? And where in the statute would we say that there's a deadline to do it? Because it seems to me that's the critical thing that Jones answers. And I'm trying to find out what's left for purposes of our analysis in this case. And I very much appreciate your grabbing the slender reed that is the Martinez distinction. I'm just trying to see how far you can bend with it.
I'm with you, Judge. So if I'm hearing you correctly, the question really is, if the blood is seized, the privacy interest is no longer there. So how can you argue that they need to then follow some sort of timeline when they don't even need the warrant to test the blood? Am I hearing kind of the question correctly?
Or a second warrant, correct.
In this particular case, I think the only thing that I can point to you is that a warrant was granted for the forensic analysis. Whether or not they needed to get that additional language in there at this point, I think is irrelevant, because based on the information known to the magistrate at that time, he made a decision based on what they were requesting of him. And if they requested of him, hey, we want to forensically analyze this as well as seize it, then I think we have to go to the execution, which takes me to the other argument, which is really what this case is about, is when does execution occur? And that's really what Jones answered, in my opinion, after reading it, is that Jones said execution occurred upon the seizure of the blood. And I just want to touch on something the state had mentioned. When they were talking about the Jones opinion, they were saying that it was based on the language. And in here, the difference is the language in this warrant is different, to my understanding, than that of Jones, in that it requested the permission to analyze the blood. And because it requested the permission inside the four corners of the warrant, then we have to see, was it executed within that timetable of the 3 days with 1 day in front and 1 day behind? In this case, I don't think that there's any argument that it was not executed within that time. It's just a matter of what does that execution term mean? Is it upon the seizure, which is the same as what you would do when you drew the blood? And this is why I bring Martinez into it. If the seizure is only one part of it, and the distinct and separate search of the testing is separate, then there is a separate execution that must occur. And that separate execution that must occur, the state is arguing that it's done upon the seizure as well as the seizure of the initial, hey, can we take the blood? And this is as I put in my, and this is something I've wanted to say for a while, leads us to the expression of expressio unius est exclusio alterius.
Alterius, yes.
Alterius.
Yeah, I wanted to play with you with that, so I'm going to here. That is a canon of construction to resolve ambiguity, right? The expressio unius canon. But the section that you're fishing from starts with if the warrant is in connection with a phone and data, right? But this is not in connection with a phone or data. So what's the ambiguity to resolve?
So that's what I wanted to go back to, is that because the legislature had the opportunity to add a section regarding blood tests and its execution and how long you have to do that, and it could be, if it's seized within that time period, that 3 days, then you have additional time to test, just like in forensic phone data. They could have put that in there, but they did not.
They could have put a lot of things in there, but that doesn't create an ambiguity, does it? I mean, each one of these sections stands alone, and the section you're trying to draw from begins with the plain language, as I understand it, of phones and data. Arguably, even more arguably, I think, than Martinez would suggest, with respect to a phone or electronic device, you have to seize the device. There's obviously privacy interest and property interest in that. Then there's the data. And the US Supreme Court's telling us data has its own privacy interests attached to it. Now here we're talking about something else. If your argument were correct, let's accept for the moment that we're empowered to go searching for canons to resolve ambiguity here. If the state has a valid warrant to pick up blood from somebody or any other body fluid or DNA, stores it in a freezer somewhere, and 25 years later, on a hunch, tests it to see who the Hillside Strangler is, in your view, that second test is too late. So if we can identify a murderer or serial murderer off of stored DNA, that has to be thrown out, correct?
I would absolutely actually agree with that statement.
Why would the state want to do that?
Why would the state want to store it and not test it? You know that.
No, I can understand why they want to. We have all kinds of unstored rape kits here in Dallas County. I think Mr. Allen can tell us all about that. I'll bet, but I bet none of them have been tested within 3 days.
Well, that actually
let all those guys go.
That's where I got that expression from, because I am actually with another court in this, or another case in this particular court. We have that very issue. In which I
understand, but what's the rationale for why the legislature, if there's ambiguity, would have wanted to exclude the possibility of obtaining and using proof that was legally and validly obtained at the time pursuant to a search warrant, but not tested within 3 or 15 days?
I think the goal of the legislature, when I read the canon and in looking at the way that they phrased that particular article of 18, chapter 18, I look at that and saying they want things to move. They don't want them to just sit there. You have a specified amount of time in which to act so that we don't have stale cases sitting on our shelves for 25 years. That's what the entire new rape law statute of limitations was done in regards to, so that we don't have cases that just sit there. We need to act, and the police need to be forced to act within a reasonable amount of time, which is why these canons and why there are regulatory timelines exist. To force them to not sit.
That's with respect to, at least with the language in paragraph 1 that I think this is pertaining to. Where is there a timeline separate from obtaining the information, in this case, the blood, or making the first, what you would say is the first seizure, and not that, where's the textual support for the second event being the analysis, being a search, is on a timeline?
My textual support for that is that the plain language, when you put into a warrant, the affiant requests the authority to forensically analyze, you are asking the judge, in this case, Hal Turley, please give me permission to test this blood. That's what it is. You're not.
But what else would you be doing? You're not going to write red rum and backwards in front of a mirror with it. I mean, the police are there to conduct the search. I mean, I don't understand why that adds to our understanding of what the magistrate thinks he's authorizing by signing the search warrant. And frankly, in a way, what does that matter? If your argument is statutory, where's the limitation on the executive branch in terms of what it's going to do in ferreting out crime and prosecuting it? That has to be in the statute, right? Not in
That's why I
head of
refer back to that statute, is that when you do not have a specific timeline extending the ability to test it, or in this case, the cell phone data is the best example of this, because it's not enough just to seize it. You get a warrant to seize the cell phone, then you have to get an additional warrant to examine the cell phone and look at the data. This is, to me, somewhat of a similar situation. You've got a warrant to seize the blood. Now, instead of getting an additional warrant with its own language to test the blood, you included that language in the same warrant, which I see no problem with. And the judge gave you the ability to do both. So you did what you were supposed to do. You seized the blood within 3 days. But here, according to the language, unless there is an exception, the language is plain. You have 3 days. And in this, the second part of that warrant, which we consider a separate and distinct search, according to the Court of Criminal Appeals, is to forensically analyze. And they simply did not do that within the 3 days.
All right, this is my last try. I'm going to ask, where do you find the deadline for what you artfully describe as what we see as the second problem from Martinez? Where is the clock on that?
The clock on it would be 1807A3.
Okay, that's cell phone.
And other than that statute, do you have any authority that requires that search warrants authorizing the blood draw must also expressly authorize the testing and analysis of the blood sample in those?
Actually, no, I have nothing suggesting that the blood draw request must also include a forensic analysis request. Nothing along those lines. That if I'm making that argument incorrectly, I don't want to confuse the court saying, I am saying that both of those need to be in there. That's not what I'm saying in this case, because both of those were in there. I'm saying if you include both, then you need to do both. You need to seize within 3 days. And because there's not an exception, you need to execution is the seizure. You also need to execute the second part of the warrant, which is forensically analyzed within 3 days. And you would not have needed to do that had you not put it in there, but you put it in there in the warrant, so you got to do it. And I guess the way around that is to say that the Court of Criminal Appeals is saying that you don't have a privacy interest in blood once it is seized according to a valid warrant. That I can see how that would make my argument moot. But as of yet, we do not have that decision from the Court of Criminal Appeals saying that's what Martinez means.
Let's assume I'm with you that we have a second request in this warrant. If Jones says that there's no clock on it from the statute, where in the search warrant or the order authorizing it did the clock come?
So I believe that the difference I can make, the distinction as you pointed out earlier, is simply in this warrant, there is specific language asking for it, whereas in Jones, I do not believe that there was.
But it didn't ask for it. It didn't say, and I want to test it within 3 days.
Right. In Jones, I believe they just said we want to seize it, which is what normal warrants were stating up until that date. This, they changed it based on the Martinez case. Dallas County actually added into their warrants, their little, pre-made warrants, a separate section that says, further, we want to test the blood to overcome any Martinez challenges, not realizing that that may have added onto them an additional requirement, which they then weren't meeting.
So what you're counseling Mr. Allen is to add 3 more words to his warrant applications, at my leisure.
Basically, right? I'm asking that the legislature add to chapter or section 18, a section that says blood is similar to cell phones and that you seize it upon the seizure and you can test it later.
Okay, Mr. Lester, you got a minute left. Anything else?
That's all I had, Your Honor.
Okay, thank you. I think we'll finish up. Mr. Allen, do you have anything else for us?
3 short points on that, Your Honor. The first, just with regard to the basis for which the trial court granted this, and I may have misunderstood Mr. Laster, but I believe he indicated the court granted this motion because that language, that extra language authorizing the analysis was in the warrant. Looking at volume 8 of the reporter's record, page 4, where the court gives its ruling. I would dispute that it based it on that. I would leave that to the court to determine whether that's the case, but I don't read that ruling as aimed at that extra language. It seems to me to be aimed at the statute 1806 and 1807, where it deals with 3 days. Second, just last week the Court of Criminal Appeals handed down Crider. And basically what they said in Crider was, look, they were called upon to answer the question of whether or not the state would have, or whether or not there was a Fourth Amendment violation by introducing blood and alcohol analysis in the absence of specific authorization in a warrant or a separate warrant. And they came to the conclusion that, if the state obtains blood by way of a magistrate's determination of probable cause that existed to justify the seizure of the blood for the purposes of examining it for its evidentiary value, then that magistrate's determination is sufficient to do the chemical testing of the blood. For all practical purposes, it says you don't have to have that specific authorization, and you don't have to have a separate warrant if that warrant is granted on that basis. So the bottom line is the language that's now in this warrant is almost superfluous. I mean, Crider and Martinez and all these were dealing with Fourth Amendment issues, and we're dealing with this. Basically, it's a state law statutory issue. And the issue is, do we have a warrant issued under Chapter 18 that gives permission to seize this blood for that purpose? And if it does, the execution is the seizure of that blood from the person. And just one last thing under the state statutory construction on this, that provision is not a command. I know this seems odd. That's not a command. A search warrant is a written order commanding the peace officer to search for and seize property. Whereas that extra blurb in the warrant, authorization is hereby given. Although I would admit it would be exceedingly odd for the state to grab the warrant and say, this is all we're going to do with it. We're just going to hold this. It's not a command as defined under the statute. It's extra permission or authorization. And that would certainly overcome any Fourth Amendment issue, but this is about when it was executed. With that, Your Honor, we would once again ask the court to reverse the trial court's order and remand for further proceedings.
Well, I want to thank both counsel. You've done what I think is an exceptionally good job with an interesting little argument with the twist of late case law. So thank you very much. We will take this matter under advisement, and I hope everyone is well. Thank you. Bye-bye.
Thank you.